Okay, everybody, let's get started. Thank you so much, everyone, for joining. So my name is Rachel Knowles. I'm the Director of the Centre for Access to Justice here at UCL, and I'm delighted to welcome you all to this event. I'm joined by a fantastic panel of speakers. You may notice there's a small change in the lineup, a couple of small changes in the lineup. We've had, unfortunately, the MP, Abtisam Mohamed, who was supposed to be with us, has had to stay in Parliament for urgent parliamentary business. We've literally just heard less than a minute ago that she might be able to join us online from 6:30. We're currently trying to work that out and try and make that happen if we can. And you may also notice that Sue James is unfortunately, sadly, not with us and is sick, and the wonderful Victoria Strandmann from PLP has stepped in to replace her to talk about the practitioner perspective that we're dealing with. I'm also joined by Gersi Istrefi from the Shpresa programme and Dr. Emma Marshall from Exeter University. And they are going to talk to us about various things to do with legal aid and access to justice. I will let them introduce what they're going to speak about themselves. Just some housekeeping things. We're not expecting any fire alarms, fire drills, anything like that. So if you hear one, please get up and leave the building downstairs the way you came in. In terms of how I was proposed to run it, I would suggest that we try and hold all questions till the end after everyone's had a chance to speak, if that's all right. And then at the end of the event, after we've had a chance to ask some questions, there'll be some drinks and stuff out there for everyone to enjoy. If anyone can't hear me, please do shout at me, but hopefully you can. Without further ado, I'm going to let Emma introduce herself and tell us what she's talking about today.
Thanks very much, Rachel. Thank you to Migrants, Organise and Public Law Project for inviting me to speak, and to UCL for hosting this event. I've been asked to speak about 3 reports, so I'm going to do my best to do them justice. One of them is by Migrants, Organise and a number of other organisations, so No Accommodation Network, Refugee Action South London, Refugee Association and Haringey Migrants Support Centre, on the quality of immigration legal aid advice. The second report that I'm going to speak about is about the use of remote advice for asylum and immigration services, which was written by Dr. Joe Hines, who is here in the audience, of Public Law Project. And finally, I'm going to speak about a report that I co-authored. I worked on with a number of other people. So thank you to Migrants, Organise and Public Law Project for their involvement in the project as well. And I wrote it with Sian Pearce, maybe here, Sian Pearce and Dr. Samuel Engel from the University of Exeter, but also worked with other colleagues on this as well. So I'll talk a bit more about that in a moment. Just to introduce myself, I'm a lecturer at the University of Exeter, but my background has been working with refugee communities in the Southwest since 2008. So I worked with an organisation called Refugee Support Devon, which I ran the drop-in service for nearly 5 years, until about 2014. And I've had long involvement with them. I'm currently a trustee working with them, and we provide immigration advice services at level 1 and level 2 under what was formerly the Office of the Immigration Services Commissioner, now the Immigration Advice Authority. So my background is really about thinking about some of the issues with access to justice and access to immigration legal aid from this particular kind of geographic perspective in the Southwest, which is an area where access to advice has always been an issue, not least because in that kind of rural part of England, even for areas where there are some advice services, actually a lot of people live in rural areas where it's going to be quite difficult to travel to get to those in any case. So it's always been an issue, but certainly it has been a significant issue for the people that I've worked with over the last, since the Legal Aid Sentencing and Punishment of Offenders Act, which came into effect 12 years ago. So I'll talk a bit more about that as well. Okay, so that's some brief part of my background, and what I'm going to do is just move through the 3 reports. Do let me know if I'm aiming for past or slightly before that. just tell me if I'm running out of time. So the first report that I wanted to speak about is the report by Migrants, Organise and other organisations on the issue of the quality of immigration legal aid services. And what is really key here is that when we think about access to justice in the context of asylum and immigration, often we are talking about the lack of services and absence of services. Often we hear about advice deserts. And what this report does is emphasize that, in fact, where these services do exist and where people can access services, there is this additional issue that actually quality is also inconsistent. So this has a number of causes which are set out in the report, and you can have a look fully at the reports in your own time. But I'm just going to try and summarize some of the key things that come up from this. So there are certain things about the way in which the legal aid scheme works, which disincentivizes good quality service provision. And other academics have written about this as well. So Dr. Jo Wilding, and I will reference Jo's work also in the room. So we have lots of expertise in this area. So some of the reasons that people really need access to good quality advice when it comes to asylum and immigration are that, firstly, immigration law is an extremely complex area of law. The immigration rules are very long. They're very difficult to understand. In my experience, practitioners have sometimes got it wrong, as well as Home Office decision makers. So even if you are familiar with these rules, it's difficult to navigate them. And certainly for people who are navigating this immigration system themselves, this is a really significant issue. But also the stakes for individuals in this area are also really high. So we're talking about the protection of people's fundamental rights, risk of return to persecution, to torture if things go wrong when it comes to the asylum context, other significant harms that people can face if they don't have access to justice, access to the legal services that they need, and ultimately are able to protect their rights through what is quite a complex system. So as the report states, having a well-trained, well-resourced and dedicated representative is not just about a right, but a requisite. For some, justice will be impossible without this. So in many cases, people are forced to choose between accessing poor quality advice or having no advice at all. And this is the reality that people are facing in the current system. There are also other wider issues that go beyond just legal aid. So although the focus here is access to justice, we have to think about this within the system and other policy decisions and practices that go with this. So for example, Home Office decision making is also factored into this. Good quality advice is necessary, particularly where we know that Home Office decisions may be incorrect at the first instance, which we can see in the reasonably high success rate at appeal. So there are these kind of wider factors to think about. But the report itself is really important in documenting some of the issues around quality and setting out recommendations for a number of stakeholders. So including the Ministry of Justice and the Legal Aid Agency, but also the regulators, the Solicitors Regulation Authority, the Home Office, and also immigration legal providers themselves. And quality has tended to be something of a side note, I guess, in conversations about access to justice, because a lot of the urgency of work and conversations around legal aid have focused on advice and the absence of services. But what we see is that there is an issue with quality as well, where those services do exist, and the way in which there are factors within the system that perpetuates this. So this report does follow work that's been done by others, including regulators, the Legal Services Board, Bar Standards Board, the Solicitors Regulation Authority, but it adds an important perspective and kind of brings focus back to this issue across the legal aid sector. And the findings are based on 46 interviews, so a really significant piece of work, and well done to the organisations involved in this. Around half of the participants were advisors themselves and half were people with experience of the immigration system. So a really important mix of perspectives. So I'm going to touch on the Legal Aid Sentencing and Punishment of Offenders Act, or LASPO for short. Others may want to come back to this in terms of the changes that it made. But the thing that I want to draw attention to is the way in which it changed the scope of immigration legal aid. And I know people in the room may be aware of this and others may not. So just to set out what happened here. Immigration legal aid was previously covered apart from some specified exceptions. And LASPO essentially reversed this, so took everything out of the scope of legal aid in terms of immigration and just specified the categories of work that remained. So asylum cases and also some domestic violence work, trafficking cases, detention, judicial review. So there are these specific areas or categories of case where legal aid is available. Everything else is out of scope, although it is also possible to apply, even if cases are out of scope, apply via the exceptional case funding scheme. So there's a separate application process, essentially. So as the report notes, many people attribute the issues around capacity in the sector and ultimately quality to the scope of immigration legal aid as it is, as well as some other factors, including the fees, so the amount of money that providers get paid for this, providing this advice and representation, and also issues with billing. So the report does two key things. First of all, it identifies issues around what good quality advice or poor quality advice look like, and then also what the causes of poor quality advice are. So it's important to note that when we think about immigration advice, it's highly regulated. And one of the reasons for this is that regulating advice is about improving the quality, because often it is a layperson who has little kind of awareness or kind of is able to finds it difficult to make objective judgments about what the advice they're receiving looks like in terms of the substantive law. So it might be very difficult to judge whether the actual advice itself is correct or not. So this is one of the kind of the points of regulating, is to improve quality and to ensure that people are getting access to advice that is both correct and appropriate, but also the practices that go around this. So the report is really important because it emphasises that this issue of quality is not just about the kind of the specific regulatory issues, but also about the experiences that clients have and what will affect their perceptions of whether they're receiving a good or poor quality service. And sometimes these are also linked to the issues with regulation. So, for example, some of the poor quality examples of things that happen across the sector are that when somebody does find an advisor, and often this is very difficult and people will spend time searching for an advisor, it may be quite difficult to get one. When their case is then taken on, it might be a really long time before they hear anything back from that advisor or before things start to progress on their case. So this is something that the report kind of identifies, but it is kind of there are widespread issues with this people know about. People might also not be informed of really important pieces of information. So, for example, if an asylum case is successful, the individual may not be informed that they have certain entitlements, like the right to apply for family reunion. Individuals might also not be given the opportunity to be involved in their case, for example, checking important documents, which is an important part of ensuring quality advice. And also people may not be offered the chance to meet their advisor in person. So this will segue nicely into the second report that I'm going to talk about, which is Dr. Joe Hines's report on the use of remote advice for immigration and asylum work. So part of the kind of the background context of this is that technology has long been discussed as one way to improve access to advice, particularly in the wake of the cuts under LASPO, but also in terms of the capacity issues across the sector and the gaps in geographic in geographic provision. So using remote advice can be beneficial. But after the pandemic, or during the pandemic and after, there was this sharp increase in the use of remote advice being implemented for very practical reasons. And given that there are issues with capacity in the immigration legal aid sector, it makes sense that in terms of efficiencies, there are reasons that remote advice can make sense. But what this report does is to look at these issues more closely and think about why remote advice is being used and the impact this is having on client experiences. So although it can be more convenient for some legal aid providers and also for clients, particularly where you might have short consultations, clients might have medical conditions that make it difficult to travel, or there might be other reasons that kind of make a remote call appropriate. The report highlights that actually there are also some potential issues around remote advice provision if it replaces in-person provision, and this is closely linked to these issues of quality. So, for example, it's really important that clients can meet their advisor in person often for establishing trust and also for feeling that their case is being taken seriously. So, whilst remote advice can be appropriate in a longer term relationship between an advisor and their client, often an in-person meeting is needed initially to establish that trust. It's also worth noting that the asylum process is a very emotional process and traumatic, and can be re-traumatizing for individuals. So in these types of cases, it might be necessary for someone to speak in person rather than remotely with an advisor. And there can also be logistical considerations. So it might be because somebody doesn't have a private space to be able to talk to their advisor unless they go into the advisor's office. But it can also be that there are resource issues, for example, not having phone credit for a long phone call. So these are the kinds of things that will affect client experiences of remote advice. And we really need to better understand then, and this is the point that the report makes, we need to understand how client outcomes are affected by the increased use of remote advice, and how it influences client behaviour. Because, for example, the information that an individual shares with their advisor will have an important impact on the way that the case is handled and the advice that they ultimately get. And this is something that I've seen in my own research as well. Having those initial conversations, understanding the background of the case are really important. Having a trusting relationship so that a client can share the full details of their situation, which might have a significant impact on ultimately the route that their application takes. And it's also worth noting that many of the challenges and barriers that are generated by remote advice are also related to these wider issues with the legal aid system, and particularly the collapse of provider capacity. So often the issues that are coming up for individuals are related to these wider issues. So got about 5 minutes, so I'm just going to touch on some. That's okay. Touch on some of the causes of issues with quality around legal aid, particularly because it's worth saying that the way the scheme operates at present operates as a disincentive to providing good quality advice, and so this is something that Joe Wilding's work discusses in great detail. But essentially, we're thinking about a scheme that at a general policy level is about the reduction of overall spending and the targeting of expenditure to particular groups, or kind of the most at need, as it's worded. And this filters down to people who provide legal aid services, where these services are then being pressured to be financially viable and efficient, but this comes at the expense of quality. So the kind of the squeezing of services has this wider effect. And there are some things within the scheme that operate as a specific disincentive. So, for example, fixed fees, because providers won't spend more time on a case if they know they're not going to get paid for that time, unless it goes over a certain threshold. The fees are also low, which is something that's being reviewed at the moment. But the report by Migrants, Organise and others talks about the warehousing model. So this is where firms will take on a very high volume of cases, but offering very little time to clients. So they're maximising the money that they can make from the fees they do get. Or the streamlining model, which is essentially taking on cases just in relation to a specific area of law. But then there's this de-skilling in terms of kind of wider understanding of the immigration rules. And then this also has an impact on quality. We can also note there are issues in the sector around recruitment and retention of workers, and this also feeds into sustainability and has a negative impact on quality. And this means that ultimately people are having to choose between poor quality advice and no advice at all. So the point I'll just come on to in relation to the work that I have been working on and the report that I co-authored, very briefly to sum some of this up, is that one of the kind of the key rationale that lies behind LASPO is the saving of money. And we can see from these reports that the money that's been saved from LASPO in terms of the overall legal aid expenditure has also had these negative wider effects. So in fact, for immigration legal aid, the saving was estimated at about £15 million a year, which sounds like a lot of money to most of us. But if we think about this in the context of other government spending, this is a very small amount. So I would just draw attention to some key points from our reports on the kind of the value for money points, and whether LASPO has really just shifted costs to other places. And this was about trying to bring together some of the work, some of the existing qualitative research that's already been done, and also by Joe Wilding, but also recent reports by the National Audit Office and Public Accounts Committee, looking at this in terms of the legal aid scheme, which is £1.8 billion of spending a year, 2022-23. So this is a very tiny amount of money. There are costs where we don't have effective processes of allowing people routes into employment and kind of longer term opportunities. And then there is also this knock-on impact on spending in other parts of government, including local authorities, but also we can think about Ministry of Justice budgets, including, for example, the increase of people in tribunals who don't have representation. So all of these issues around capacity and quality have these wider knock-on impacts. And so I would, the kind of the key recommendations coming from these reports and things that I think we need to be thinking about are around the wider issues on Home Office decision-making, the complexity of the immigration rules, restrictive policies that affect people's access to benefits, restrict access to permission to work for asylum seekers, but also what we do to ensure the sustainability of immigration legal aid, how justice policy sits in the wider policy context. We need a better understanding of the quantitative impact that LASPO has had across government spending, I would like to see the scope of immigration legal aid broadened to bring back all work, to reduce some of these issues that people face in accessing advice, and to ensure that essentially the legal aid scheme provides an incentive to provide high quality work, rather than providers having to operate in a way that pushes the amount of advice they can provide and the quality of that. So I think that's all I've got time for. So I'll leave it there, but thank you very much.
Thank you so much. All right. So yeah, perfect. So now it's over to you, Gersi.
Hello, everybody. My name is Gersi, and I wanted to start by asking some question to the audience, and if they raise their hand, if they've been if they are related to the question. So my first question here is who here has experience of working in legal aid? And who has experience of using legal aid? So who I am and why do I care about access to legal justice? My name is Gersi Istrefi, and I come from Albania, actually from a small town which is called Kukos, the first time ever to be nominated for a Nobel Prize for its role to refugee, 5 times more than local population, and the city where I'm from welcomed them and opened the door for them, making sure they were fed, looking after them, and after the horror of the war they went through against Serbia. Why am I saying this? Because here in England, it has become so worse that who comes here to seek refuge from persecution, war, is considered criminal. I came to England when I was 16 from a small town, which I talked before, with one hospital, one mayor, where everybody knows everybody, to a big city with different buildings, big buildings, different mayors, and a system which people here don't really understand. People who are born here don't clearly understand. So why do I care about access to justice? I care because I don't want my friends, people who like me, don't understand the system from the childhood, and your life grows wrong from there. And then you suffer the consequences later, which I am still suffering now. I'm still an asylum seeker for nearly a decade, without knowing if I ever gonna be accepted in this country, not being able to start a future for myself because of the restriction in asylum process. Why do people need legal aid in the first place? When they are going through the immigration system, we all need legal help to navigate and fight back against the complicated immigration system, especially now that has become so vile against people who seeking refuge. Attacks from media, from different people in politics and media. Protest against asylum seekers, a controlled life from the Home Office. These are 3 examples that has happened recently and continue to happen now. So I have some questions, so I should have explained. I have some questions that I'm gonna be answering. Where have you seen or encountered challenges in accessing good legal aid? What impacts does this cause? Well, when I came here, I never knew about the system. I never knew about the immigration system because in my country, we don't have immigration solicitors. So when I came here, it was a new thing. And the first time I met my solicitor, I didn't understand. But when you come here, you tend to say yes to every questions. And you never say no because you don't know what they're talking about. So it was from the start, I had trouble understanding the case and what's going on. And unfortunately, I didn't have a really good solicitor at that time. So she didn't explain my case very well. And from then, it went downwards because I received a negative decision. And then from then, she didn't explain, like I have to find some proofs. And luckily now I found those proofs and tried, but still the mistakes you do from the Home Office, it takes time for them then to send it back after you receive a negative decision. And you go back down the business fighting for the Home Office for nearly a decade. And it's not just me like dealing with this. There are my friends as well, which I've asked one of my friends as well to share his experience here with you. So I wanna tell a story of one of my friends. He arrived in UK to seek help because he had a lot of things going. He had a lot of things happening to him and his family in Albania because of blood feud. As soon as he arrived here, they put him in prison straight away because he was crossing the channel and they thought that he was driving the boat. And because of that, they put him in the prison straight away. After 3 months, thank God he was released and he started to do everything right. He was living in a hotel accommodation provided by the Home Office. He was going to the college to try and become an electrician. He was going to volunteer. He was getting mental health help till the Home Office refused this case after 3 months. After 3 months, they refused this case, and then after he found out that his case got refused after 3 months, and they told him like he had to leave the accommodation for 2 days, and he didn't have nowhere to go. He didn't have nobody here. So what did he left sitting in Stratford on the stairs, and from then he met some Albanian people, which he was exploited here. After 14 days, he was arrested again in a cannabis farm without a phone, without food and everything. And he had to go in front of the court without any support. And thank God this organization, SLRA, got involved, tried to help him. And he went in front of the judge and the judge accepted him that he's been exploited. But because he pled guilty, that means he still has to be tried as a criminal again. After a long fight, he went to detention center. He spent like 3 more months there as well. And then finally he got released from the detention center through all this. And now he has to go back on the system, do a fresh claim and wait a few more years, or maybe hopefully it's gonna be a better decision, a quicker decision to get another decision. And I don't know, because like he was doing everything right and to be expected and to go down this way because he was volunteering to Shpresa program as well. And there is a good solicitor there, which is now my solicitor. And he was on the waiting list, but the capacity of that solicitor is like, she was helping 20 of us and trying to help all of us. But the capacity was full and she couldn't have a solicitor to try and appeal his negative decision from the Home Office. Unfortunately, it didn't happen for him. So now, hopefully now he's out, he's okay, but still the mental health going through, he's getting worse and worse, waiting for him to have the right to work, to drive, to feel free in this country. There are really good aid solicitors, but impossible to get clients because the capacity is full. And there are poor legal aid solicitors out there too. But how can somebody from another country who doesn't speak English understand who is good and who is bad? How can they decide? When I came here, I didn't speak as well English, and I didn't know if she was a good solicitor and a bad. She used to call me and I used to think, oh, she's doing a good job. But later on, now that I got the experience and I got involved with other organization, I understood all my case. So yeah, as I am from Albania, we tend as well, the way we find solicitor is like, we ask people that we come from, sometimes in internet, sometimes in Facebook groups, and sometimes in person. And most of them, like somebody has got the papers because of a solicitor, they got involved. And then later on, there are so many cases going there, but nothing is being done. What does a good solicitor do? First, I would say they explain your case and then they take your statement from you, which my solicitor did. My current solicitor, because I had so many solicitors, which she did. And the way she did it is like, as soon as I went to do the statement, she used to bring these stress balls to bring me in a room, these things, and to make me feel like I was the boss and try to make everything right. And as well, my anxiety was really bad at that time because we used to do so many interviews and long hours. So I told her, and I was a bit shy to tell her, I told her like, my anxiety isn't bad, can we do short interviews? And she agreed, and she made me feel like I could trust her. I could tell her everything from my part, which most of the solicitors, I'm not here to judge, but most of them don't do it. It is best as well. It is very important for an Albanian asylum seekers to know most of this thing as the experts, medical expert, medical expert, country expert, because it is very hard for an Albanian asylum seeker to get a positive decision at the moment, because they classify Albania as a safe country. But on the guideline of the Home Office, it doesn't sound as a safe country. It is a lot of work for a solicitor to do all this job as well. With the current pay from the legal aid, which is getting lower, they're not giving us a chance to fight and to make our case heard somewhere as well. That's why it is important that we all here try to raise the legal aid, and they are only one who are not giving us up on us and still working despite the lower cost in legal aid. What changes would I like to see, and who needs to make these challenges? We should be able to have direct access to solicitors, to reach them ourselves, not depend on charities. Charities shouldn't exist. How is it fair that Home Office does the interview and not make sure that you have a solicitor, but they continue to make decision on their case? We shouldn't need legal aid in the first place. The Home Office shouldn't fight against us so much that making life unlivable here. We should be able to live in freedom. The system is less complicated. The system should be less complicated. We shouldn't have to convince people to believe us the whole time and repeat our stories multiple times, which is my story. I don't have to repeat it to everyone that I have to GP, different solicitors. It's my story about my family, it's my dignity that I don't want to share it, but I have to because I don't have a choice. If I don't share that story, that means I'm not gonna be able to get asylum. We shouldn't have, yeah. Why do we treat immigrants as criminal? Why don't we welcome people and make the most of the immigration? The government needs to make these changes. Give a voice to people that don't have a voice otherwise. No one wants to be treated like a criminal. I'll tell you this, no one wants to be away from their family for years. I might not understand it now because I'm not a father, but I don't have children, but only thinking how my mom would feel or how she felt when she goes home and her kids are not there. Not just for days, for years. It's a torture for a mother. And there is not a single mother here that could deny this. Only those who live it would understand it. The system should be less complicated and more effective, trying to help those people to get into education, work, and contribute to this country. It will only benefit the country at the end. There are so many people who have become successful because of England, such as Dua Lipa, Rita Ora. But we don't call them criminals because they are in a status where they made it, and there are so many people like Dua Lipa and Rita Ora who, if we support them, can become as better as them and maybe greater than them. And that's for me all.
Thank you so much.
All right.
Now, I need to just summarize it all for everyone.
Evening, everyone. Thank you so much, Gersi, for that really powerful speech. It was really great to hear from you. I'm really delighted to be here to speak on this really important topic on behalf of the Public Law Project. I'm the legal director at the Public Law Project, but my background is that I've been a solicitor practicing in legal aid for more than 15 years, primarily in public law and community care. Public Law Project is a charity comprising of researchers, lawyers, trainers, and public law policy experts. And our aim is to make sure that state decision-making is fair and lawful and that anyone can hold the state to account. As a result of that, we've had a really long-standing interest in the health of legal aid. And we were involved either as a claimant in our own right or representing others in a number of important challenges to LASPO, the Legal Aid Sentencing and Punishment of Offenders Act that Emma has already mentioned, including successful challenges to the Legal Aid Agency's Exceptional Case Funding Scheme, to the attempt to introduce a residence test, to the evidence required to access legal aid in family law cases for victims of domestic violence, to propose changes to the Housing Possession Court Duty Scheme, and to the way in which the legal aid agency treats capital trapped in a family home as making certain categories of people ineligible for legal aid. We've also contributed substantially to the research in this area, including through some of the reports that Emma has mentioned already. And we hold public law and immigration legal aid contracts ourselves and represent many individual clients in a range of cases, including significantly for this audience, the second round of the Rwanda litigation last year. So as Emma has already mentioned, the LASPO is the most recent substantive act of Parliament that determines what is in scope of legal aid and what is not. It was an act that made huge cuts to what was in scope for legal aid, not only for immigration, but across the board in other areas as well. But it nevertheless retained many areas where individuals interact with the state in the context of huge power imbalances in terms of the power that public bodies hold over people's lives. Section 1, subsection 1 of LASPO imposes a duty to secure that legal aid is made available in accordance with that act. It's not a discretion. It's not what is sometimes called a target duty. It is a statutory duty imposed on the Lord Chancellor by Parliament. And it's against that really important duty that we're looking at the approaching collapse of the legal aid system. And you have to see it in that context. You have, on the one hand, this really important duty imposed by Parliament to provide legal aid for those areas which that act has determined there should be legal aid. And then you look at a system not only in immigration and asylum legal aid, but in all areas of legal aid, which is either already collapsed or approaching collapse or looking at collapse, depending on which bit of it you're looking at. And so I think I see nods. I think people here know that that is not an exaggeration of what we're facing. Let me paint you a picture of the current system, which will be only too familiar for anyone who practices in this area in the room. I'm going to be talking quite a bit about the practitioner perspective, because that was what I was asked to speak about. It goes without saying that what really matters is the clients and the advice that they receive and the outcomes that legal aid practitioners can achieve for them. Nobody goes into legal aid because money is the object for them. But ultimately, in order to have a functioning legal aid system, it has to be commercially viable for those organisations that provide it, whether they are in private practice or charities. So what we have are fee structures that are complicated and at levels that are nowhere near to being commercially viable. Fees that in many cases are not paid until the very end of the case, even if that takes months or even years to reach a conclusion, without the ability to recover the costs, even of the expenses along the way, like interpreters' fees or expert reports. Fees that are for the main part paid at the same rate, regardless of how experienced the caseworker is and regardless of the complexity of the work. A requirement to work at risk in many cases. So that means doing the work without any guarantee of whether you will actually get paid for it at the end or not. And large amounts of unpaid work, including things like liaising with potential clients before cases are taken on to get the case set up, at the end in terms of the work necessary to bill and close the file, in terms of actually supervising more junior practitioners and training new practitioners up, in terms of the administration of the whole scheme, and in maintaining various accreditations which the legal aid scheme requires. So against that backdrop, we've had the review of civil legal aid, called ROCLA, which was launched by the previous government in January 2023, over 2 years ago, and for which the results have now been published alongside the recent fees consultation, which already has been referenced. And that is extremely welcome. It's a direction of travel which feels much more positive for the first time in many years. And we really welcome both the fees consultation in housing and immigration, as well as how candid many of the ROCLA reports are in terms of the scale of the problem that we face in civil legal aid. The recent consultation that's been conducted by the Ministry of Justice in relation to fee increases, specifically for housing and debt contract and the immigration legal aid contracts, is what I want to turn to next in the context of this review of civil legal aid. It's really welcome. It's really positive progress. The question is it actually going to see a reverse of the tide that we've seen towards collapse? So depending on the specific subcategory of work, the proposed fee increases represent between around a 10% to around a 30% uplift in legal aid fees. But you have to see that against a backdrop of hourly rates, which were last increased in 1996 and were then cut by 10% in 2011, with fixed fees which were set in 2007 based on those 1996 hourly rates. To put it in context, the proposal includes hourly rates being increased to sort of a variety, but around £67 an hour up to about £80 an hour, broadly speaking. If you contrast that with the solicitor's guideline hourly rates, which are set by the courts, and where if you are in a court case where you can recover your costs from your opponent, those are the starting point for what a cost judge will be looking at that you can obtain. And that is based on evidence from a much wider range of sources. So the 2025 solicitor's guideline hourly rates for a trainee or paralegal in London, based on where you are geographically in London, range between £139 and £153 an hour. And if you go up to the most senior solicitors in central London, for, including public law work, you'd be looking at up to £413 an hour. And the difference in rates for barristers is similarly stark. So what needs to happen now? And I'm going to speak briefly to both the public law projects, but also the Legal Aid Practitioners Association's recommendations for what is needed to place legal aid on a sustainable footing, in addition to the fee increases that are proposed. And what I'm saying here is relevant to immigration and asylum legal aid, but it goes well beyond that into other areas of legal aid as well. So the rates need to be increased. The evidence that's available suggests that they need to be increased well beyond the current proposal. They've got to be commercially viable and account for both the real cost of delivering services and a reasonable profit margin, as that's necessary for any sustainable business or charity. In this country, we've chosen to have a legal aid scheme that relies on both private firms and charities to deliver that service. And as part of that, we have to expect that organisations that are run for profit are going to have to be able to make a degree of profit in order to deliver that service. And we have to make that achievable for them to do that. Otherwise, they will simply cease to do it, which is what we've seen happening across the board. It's currently not even viable for the charitable sector to cover all its costs of legal aid work without resorting to supplementing it from grant funding. It needs to include the ability to pay salaries that mean that people stay in the sector. It needs to be enough to attract new people into the sector, to reflect how challenging some of this work can be, and to be able to afford to train new lawyers and to invest in new IT systems and all the things that go with running a viable business. The increase is welcome, but it's not enough, and it's also not based on sound and sufficient data. Even after adjusting the rates to the bracket that I mentioned of between £67 and £80 an hour, the MOJ seems to accept that around 25 to 40% of providers will still be making a loss. One has to ask, what's the rationale for setting rates that remain loss-making for such a significant number of providers? Not having a commercially viable hourly rate and alongside the fixed fees, which Emma has already mentioned, drives the wrong type of behaviour and the sorts of behaviours that Emma was talking about when she was talking about issues with quality in immigration and asylum legal aid. The mechanism for keeping rates under review needs to be uprated in line with the cost of delivering the services. So there needs to be robust data gathered on what the costs actually are, and then it needs to be reviewed, regularly every 2 years or whatever is required. There needs to be a reform of the fee scheme. It needs to be simplified. Providers need to be able to claim their costs along the way more easily so that they're not waiting potentially years to get paid. They need to be able to claim expenses like interpreters' fees and expert fees, which can run to kind of many thousands per case as they go along. The administrative burdens need to be reduced, or providers need to be remunerated for complying with those administrative burdens. The Legal Aid Practitioners Association has done some preliminary research, which is ongoing, into how much time providers spend doing work around the legal aid contract, which isn't remunerated. And their preliminary findings suggest that 20% of the provider's time has actually been spent on work to sustain the legal aid contract for which they're not being remunerated. the cost assessment guidance needs to be amended so that that sort of work can also be claimed. We need to remove all the situations where providers are expected to work at risk. And there are many, but to give you 2 examples, currently, if you act in a judicial review claim and permission is refused by the court, then you don't get paid anything at all for all of that work. And judicial review is very front-loaded, so there is a lot of work required to get it off the ground. And providers are often in urgent cases effectively expected to front the risk of doing the initial work urgently before they've actually found out whether legal aid has been granted or not. This gets a bit technical now, but we also need to introduce an exemption for publicly funded cases from the fixed recoverable costs regime, which was introduced in civil in general. Currently, housing and debt work isn't subjected to that, and there are some other exemptions for certain types of claims against public authorities work, so that needs to be exempt. There is an enhancement scheme currently for certain types of legal aid where you can claim up to 100% uplift in the fees for particularly complex work, but it's only for certain categories, so it needs to be expanded across the board. Much more research is needed on the possibility of removing some of the limits, contractual limits on remote advice and requirements for a permanent office location. So in the fees consultation, that was one of the things that was proposed, that actually providers might get more flexibility in delivering remote advice. And that brings with it some of the concerns that Emma has raised in terms of the research that's been done. And there are obviously risks of larger providers potentially going round and taking up simple cases and then leaving the more complex ones. And there needs to be a strategy to encourage face-to-face advice in all areas of law where it's required. We want to avoid a situation where remote advice is being used as a way of hiding problems with access to legal aid, so making the deserts look like they're no longer there because we're saying that remote advice is available, when actually for many clients that won't be suitable. And we need to re-establish the research for obtaining and analysing the data about unmet legal need and the drivers of legal need. So for example, in the Southwest, where there is a massive desert for immigration and asylum legal aid, one of the government's solutions to that was to set up this remote advice provider list. And PLP has a report that has analysed that. But when providers agree to go on that list, the MOJ is not monitoring whether they then take cases from that list or not. So they're on the list, and the MOJ expects providers to tell it if there's a problem, but it's not gathering data in terms of how many of the remote advice cases are actually being taken. So we need to take a completely different approach to the data. LAPG has also suggested investigating the merits of a high trust model, so where the oversight and auditing is proportionate to each provider's track record. So if providers are high performing and doing really well at complying with all their legal aid obligations, then you could downgrade the level of auditing that is required. And we also need to, alongside the research that I mentioned, and in line with what Emma was speaking about towards the end of her talk, we need to investigate the costs of LASPO and the cost shifting of LASPO better, so that we can make a better case for why it's actually more cost effective to fund the legal advice rather than to try and fund the problems when they've become out of control down the line. In the immigration and asylum context, the need is particularly urgent. We know, including from today's announcement, that removals are at an all-time high. That's obviously something that the government is putting forward as really positive, but looking at it from this perspective, you have to wonder how many of those removals are taking place with people not having had access to any legal advice at all. We know that there's a massive deficit between the need for and the obtaining of legal advice in the asylum context. Dr. Wilding has assessed that deficit between the need and the provision to be 57% by analysing new asylum claims against the number of new matter starts for asylum that are being opened. And we know that even beyond that, the situation is more acute in certain areas where there are advice deserts. So in the Southwest, We heard Abtisam talk about advice deserts in Yorkshire as well, and there are lots of areas that Dr. Wilding has mapped that don't necessarily respond to the legal aid agency's procurement areas. So even in one area where, if you look at it as the area as a whole, it looks like actually the level of advice is fine, there can still be pockets within that area where actually there is still a desert. And we also are concerned that the government is not collecting data in relation to unmet need. So in terms of actually monitoring whether individuals get access to legal advice or not. So for example, from my previous practice in public law and community care, my firm on a daily basis was getting countless referrals of people who needed community care legal advice, none of which we could take. And we knew that those individuals would have gone round every provider in the same way that already happens in immigration and asylum legal aid, and they will end up not getting the advice at all, and that isn't being monitored. So in conclusion, civil legal aid provides a really vital public service, and that's the way in which it needs to be seen. It's on the brink of collapse, and urgent reform is needed, not just in terms of fees, but in relation to all the other issues that have been identified, if the government intends to comply with its statutory duty to secure legal aid for those categories of work for which Parliament has determined there should be legal aid.
Thank you.